Hello. When somebody becomes incapable, usually it means mentally incapable, meaning that memory loss is there, that some cognitive functions are no longer available, at least fully, that decisions are irrational, that the mood is erratic, that basically a person cannot be responsible for his or her actions, cannot plan, cannot manage his or her property and financial assets, and cannot manage his or her own daily care to this extent. Uh, so, in such a situation, usually there are two options to take care of such a person. Both start with the word protection, and they're called protection mandate or protection regime. What's the difference? Uh, well, there are many minor differences, but the major one is that unless it was specifically stated, a mandate in case of incapacity, protection mandate, is becoming potentially valid even before homologation when the person is fully incapable, because the mandatory bioprotection mandate usually substitutes uh, for the decision-making process of the mandator, uh, just fully for whatever decision it is. But if it was specifically stated in the protection mandate that the partial incapacity is also applicable, then there might be also a way to homologate the mandate, the protection mandate, the mandate in case of incapacity. Though the question of a degree would be still within the limit of the judicial authority, within the limit of the judge's discretion. And it might be that the powers described in the protection mandate do not match the degree of incapacity as it was established in court. So there might be a gray area here. In case of a protection regime, especially nowadays when it's very much flexible, there is no such a problem because it is established in court before a judge, like what's the degree of incapacity, what kind of care is necessary, and what kind of a power is needed for a mandatory or for a tutor to exercise uh, to to complete the residual powers of the person who is gradually becoming more and more incapable, but so far is still able to make certain decisions, maybe about daily life, maybe about just medical care, but already weak in mind enough, weak in spirit, to make investment decisions or decisions about the sale of immovable property or signing certain contracts and so forth. Second big difference, again, it might be altered by the court, but by default, with the mandate in case of incapacity, with the protection mandate, there is no need for a tutorship counsel because, again, it's presumed that the person, when he or she was capable, decided freely that this person or these people will be taking care of all the decisions, and therefore there is no need for a specific overseeing body like a tutorship council. Though, again, sometimes it might be imposed. In the situation of a protection regime, the tutorship council is there by default, meaning that as the regime is open sort of against the will of the incapacitated, incapable person, because there was no protection mandate, then there should be somebody to report to. this tutorship council is usually formed by family members or friends, and often there is a representative of the Quebec uh, public curator is there. Sometimes the public curator is the tutorship council, meaning that whoever is the mandatory or tutor should report about, usually about financial decisions, mostly to prevent dilapidation of funds to that government body. Well, as we discussed, the formal difference is that to go with a protection mandate, they should be one signed. Nowadays, usually people sign them together with their last wills, where the mandatory is designated and the powers are listed and the preferences of the person about potential care, including medical care, about potential administration of property. Those preferences are also listed in there. So in a way, protection mandate is a like not very last, but like pre-last will for the period when the person is still alive, but already is not capable of making decisions for him or herself. If this happened without a protection mandate or suddenly, because it might not be because of somebody's old age, it might be because of some illness or because of some accident of sorts, then there is only way to go is to ask to open this protection regime and ask the judge to impose the limits, because again, there is no mandate where it's listed like I wish that my mandatory be able to do this, 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 and this in my name, and in making decisions should take into account my this, and this wish. There is no such a document, so the court is there to substitute such a document when opening a protection regime. So, of course, in a way, formally, it's a bit easier to homologate a protection mandate because there you need a medical report, psychosocial evaluation report, and if there is no contestation, basically, well, the mandate itself, of course, and basically that's it. While for protection regime, there should be a lot of additional proof to establish that degree. Of course, there will be still a medical report and psychosocial evaluation report, and there will be recommendations in there. But there is no certainty about like what would the person, the concerned person, the person in the focus of all the procedure would actually want, would actually like. And because of that, there is a significant uncertainty about the appropriateness of the measures as they are imposed by the court. So this is the major difference. The rest is more or less procedural, technical, formal. But as the outcome, of course, it's recommended, even if you do not envisage at any moment that you might become incapable, it's recommended to have a mandate in case of incapacity. Of course, if it's not just a formal paper that you've never read, but if it's an actual decision that you made after a discussion with your family members, with your friends, with a notary, explaining what the outcome you wish to be there so that the notary could faithfully reflect it in the document, because otherwise you will have just a standard document allowing everything and so forth. But if you took care about it, if you thought through it, then it's preferable to have a protection mandate. Thank you and have a nice day.